Right, good morning to everyone. Today we're just going to talk about the IT3Ts and the recent messages from SARS. And I think this focus group is taking nice shape now because we can kind of stick to themes, because the more I speak to people, there's still a lot of confusion in terms of in which capacity are we talking, what do we have to do when I just do the statutory stuff, when I do the trust administration, am I exposed, am I the independent trustee? Do I have to be an accounting institution? And the accountant and the tax practitioner that we're going to speak about specifically today. And after the communication, I feel quite sorry for the poor tax practitioners, because the question that I'm asking today is the tax practitioner now becoming the ultimate reconciler and checker. And you'll see later why I'm saying so. So when we look at the important things that we have discussed before in terms of the separate engagement letters, to make sure we got indemnities in there for trustees who don't provide us with proper information, because the poor tax practitioner is sitting right at the end of the value chain. They've got nothing to do most of the time with what's happening in the trust during the course of the year, and they literally just have to report what the trustees have given them. So I think an indemnity is becoming really important when we look at engagement letters there. And again, once we do only the accounting and the taxation, and we don't do any of the other three services that, or perform the other services that we've spoken about previously, I believe it's very important that we communicate that to our clients. And and the tax practitioner is an individual appointment with SARS. It's not a company, so we probably have to revisit our PI cover and make sure that the individuals who are acting as tax practitioners on trusts, that they are actually covered through the PI. So just quickly back to my false prophets one, relevant for today. I have heard recently people started saying on platforms that the IT3Ts are on ice now. And I think they were quite surprised when SARS came out with the Government Gazette, which appeared on the 30th of May, 30th of June. So the IT3T is not the result of greylisting. A lot of people still say, yeah, we have to do all the following new things, and that's as a result of the greylisting. IT3Ts has got absolutely nothing to do with the greylisting. That is because beneficiaries have never, or most beneficiaries have never reported their distributions on their respective income tax returns. So you can see there, and that was way before these FATF measures were implemented late last year. The IT3T has been coming for a while, especially for those who are involved with SARS in their kind of discussion groups. Then again, the themes around in what capacity am I acting. If you do one or more of those four things for trusts, you can either act as a trustee, you can act as and now you're acting in an accountable institution. If you now provide trust administration services, you can be the representative taxpayer if you are submitting tax returns on behalf of the trust. So again, let's keep in mind which hat we are wearing when we perform a specific activity, when we think about which legislation we have to adhere to. And today, obviously, we're going to talk specifically about our trustee hat, because it's not just the accountant that's going to take the flak when things go wrong. The trustees are held liable. And there we talk about today, the SARS wants the appointment of the main trustee. That's a specific term that they use. That's probably the main contact person. And as a separate appointment, they are looking at the representative taxpayers. I see a lot of accountants still running around talking about the accountant or the accounting officer or the public officer, and give it all sorts of weird terms. In relation to trust, we talk about a representative taxpayer, as well as the main trustee. And SARS wants the names of people for both of those roles. In most instances, people ask me, what is it? Is there a difference? I think pretty much in our lives, us dealing with trustee, that it's mostly the same person that we speak about, who is acting as the main trustee or the representative trustee. And then obviously we have the representative taxpayer, who again may be one of the trustees, especially if you perform one or more of these activities on the left-hand side of our first slide. If you just the tax practitioner, you have to tell the clients that that is the role that you perform and have your engagement letters around that. And talking about engagement letters, you'll see later that maybe we are moving towards pricing for time rather than have a flat fee, because we all know trust tax returns have been pretty sloppy historically. Very recently, I've spoken to some accountants say, no, they pass their tax audits. They don't apply any of the attribution rules. They don't treat trust assets separately. They still, apportion the cost that's most beneficial to them. So I think those days are over now, especially when we look at the recent communication that SARS issued. So today we're talking about the SARS thing. I was going to come back to the trustee hat in terms of the master, but I think let's leave that for next time. And I think next time we're probably going to talk about the enforcement agencies. What kind of documents do you have to have ready when you're acting as a trustee, when you're acting as an accountable institution? So I think that could make out for some nice discussion. And I hope some people haven't had practical experiences with having to deal with visits of these law enforcement agencies. So I'm just starting with the changes to the Trust Property Control Act, which were effective from 1 April 2023. And two particular sections I want to have a look at there, especially because some accountants, tax practitioners are also acting as independent trustees. And I don't think today is a day to discuss whether you should or could act as an independent trustee or not, but there are a number of people who are sitting in one or more of those boxes. So one of the changes we haven't spoken about a lot, because we've been focusing so much on beneficial ownership registers and accountable institution interactions with the trustees and what trustees have to do about that. So today I just quickly want to refer to one part of section 6.1a, which is a new subsection, which deals, and section 6 deals with the authorization of trustees and the security they have to provide. And it says the following, the new subsection: a person is disqualified from being authorized as a trustee if the person has been convicted in the Republic or elsewhere and imprisoned without the option of a fine, or if they are fined for more than the prescribed amount in terms of section 69 of the Companies Act for either theft, fraud, forgery, perjury, or any other offense. Now, and that includes under this act, which is the Trust Property Control Act, and there we have our 10 million rand fines. So you may not act again as a trustee because you committed an offense. Or if you look at the Tax Administration Act, all these things are in line with people who can't act as directors. So in the old, well, in the new old Companies Act, clearly the Tax Administration Act hasn't been in place at the time it came into effect. So in the Trust Property Control Act, under this new section, they added the Tax Administration Act specifically. So now that is quite scary, because that is every person who has to comply with the provision of a tax act that's implied here. So we need to be very careful and be mindful that we may not be appointed as a trustee of a new trust if we actually have committed one of these offenses. And I've seen a prescribed amount. I'm not a company law expert, so please, anybody jump on and shout if it's no longer 1,000 rand. I could only find 1,000 rand, but that's a ridiculous low amount. So yeah, when we look at the SARS penalties and offenses, we very, very quickly over that. So I'm not sure how the master and SARS are going to keep track of people who actually incurred an offense and could potentially not act as a trustee again. But then it goes on and it says a disqualification in terms of the subsection ends at the later of 5 years after that of removal. or the completion of the sentence opposed for the relevant offence, as the case may be. So it is quite a complicated thing, this new section 61A, or the whole new section 61 that's been amended. So be mindful and check there when you can't be a trustee, and when you actually would be eligible to act as a trustee again. So in the context of what we're discussing today, and SARS has warned tax practitioners that they must do the right thing, that they must use accurate, complete data. So I think this is a good warning kind of to all of us. And so section 61A deals with the authorization of trustees and where they're prohibited. When we skip to the amended section 20, which deals with the removal of trustees, wording was added that the master may, and I put that in a big may, remove trustees if they become disqualified to act as trustees in terms of this new section 61A. So what that means in terms of trust deeds, we're probably going to have to reword our trust deeds to fall in line with the new legislation. And I think we need to be mindful. So 61A is an automatic disqualification. If you look at section 20 for the removal, it says the master may. So normally in the trust deeds, I don't do that as an automatic disqualification. The master has a discretion. So we've had some horrible examples where people were removed as trustees, who were the founders, the trustees, and the beneficiaries. And when they removed, they literally had absolutely no say over the assets that they transferred into a trust as part of their estate plan. So this can become a complicated subsection, but I want to draw particular reference to the Tax Administration Act when we do things wrong there. Okay, so the first communication came out a couple of days ago, where SARS labeled it as trust filing season, form and system changes to be introduced from 23 June 2023. So a couple of things were introduced there, or just highlighted or re-emphasized. The first one is the management of compliance matters, and SARS reminded trustees that trusts are included in the definition of a person in terms of the Income Tax Act, and therefore all trusts have to be registered with SARS. And even if you have a so-called dormant trust, we will see later that SARS made provision now for inactive trusts, which is probably very welcome because it's not such a fat tax return to submit. And the representative taxpayer has a responsibility to register all trusts for income tax purposes. So we need to identify a representative taxpayer, and that's obligation obviously sitting on the trustees to register all trusts for taxation. So in the past, a number of trusts haven't been registered. When we looked at the statistics about 2 years ago, of the 900,000 trusts that are registered, probably 850 at the time, only 300,000 were registered. After all the communication and reports in the media, more and more people have kind of woken up to the fact that they have to register their trusts. So they're up to about 600, probably more than 600 now. Haven't got the latest statistics, so it is improving. And we know that it takes still an average of 2.5 years to register trusts for taxation, because it's not automatic registration like we have with Sub C for companies. You still register the trust and then you have to register with SARS, and it's now an electronic registration on the portal. So yes, that is the first obligation that trustees were reminded of. When you have registered as a taxpayer, then all trusts have to submit their tax returns annually, obviously during the filing period, which is going to be quite interesting when we look at what they have given us in terms of dates. So all representative taxpayers must ensure compliance that tax returns are submitted, and the Board of Trustees is ultimately going to be responsible because they have to comply with all the legislation. And we can take it way back to the J417s when we agreed to be trustees or independent trustees. We agree that we do understand the law of trusts, so ignorance is not going to be tolerated. So the filing periods for this year, the non-provisional taxpayers opens 7 July, which is today, and it closes 24 October 2023. And the non-provisional taxpayers would include trusts that distribute all their income and capital gains to beneficiaries. So now you just don't wait like the accountants till the end of the year, 7 years later, because we know that's the average time it takes to submit tax returns. We now are going to have to keep our ducks in a row, which we'll have a look at later in terms of what data we have to keep and on which tax return and when the amounts would appear on either the beneficiary's tax return or the trust tax return, or even the funder, which we have conveniently forgotten over the years. So the non-provisional taxpayers, including a trust, because they aligned with individual submissions, that is if the trust did not retain any income and or capital gains. And we're going to have a look that we agree in terms of the IT3Ts whenever we submit that. The provisional taxpayer trust, however, they retain all the income and the capital gains or a portion thereof. And I always say that the trust is a taxpayer of last resort. So after we have attributed to the donors or funders, we have distributed, then in the washing machine comes out the trust tax return. So you're going to have to keep 100% record of all these rules and, you know, which amounts have to appear on which tax returns. Also in the communication, they reminded of some important changes to the income tax returns with effect from 23 June 2023, where they have now introduced a simplified passive return, which is a less cumbersome one. And it's actually limited to trust-specific activities which occurred during the year of assessment. So it's typically passive trusts, and SARS uses the words with no economic activity. So there they would think about trusts that they may hold assets like a holiday home, but there's no ongoing activity in the trust. So that's typically a primary residence and there's nothing else, or a holiday home. So that's typically where we open the bank account and the bank is going to close it at some point because there's no ongoing activity. And that obviously would include the dormant trust if there is such a thing. So I think we should start replacing the word dormant trust with passive trusts, as SARS refers to. So yes, you still have to submit a tax return, but obviously in a much more simplified fashion. Then they alerted to distributions received from other trusts. Now, this is a big bugbear of SARS, because obviously there's kind of capital gains tax implications. If the one trust makes a capital gain and they distribute that to another trust, you know, obviously gets trapped in the second trust and can't be distributed to the beneficiaries any further. And there was a recent court case about that. And so on the trust tax return, SARS very wisely added additional questions now to the wizard to actually figure out whether any local or foreign amounts were vested in the trust. So it's local or foreign in the trust as a beneficiary of another trust. So they actually want of the receiving trust. And they obviously want the number of trusts from where these amounts were received, because they want you to report per trust. So clearly the magnifying glass on any amounts that the trust receives as a beneficiary of another trust. So before you can do that, then clearly you need to know on an ongoing basis which is coming to you. So you almost have to look at the group of trusts, if there's such a thing. And then the poor beneficiary trust is going to have to report this kind of information. So you can see that it's going to be important to actually look at the group of trusts, especially when you have foreign trusts, to make sure you have timely information to submit this on the tax return. Then information on the donors or funders of the trust. This is the attribution rules that we refer to. So a trust is a taxpayer of last resort. Rule number 1, we first attribute in terms of section 7. It's not a voluntary application, it's compulsory, but you have to do that. Now, a lot of people say, and the Davis Committee in his reports around 2014, 2017, contemplated removing the attribution rules, but they would never remove the attribution rules without removing the distribution rules, the conduit principle, if you think about it, because a lot of people want to use the income and capital gains in the trust, distribute that to a number of minor beneficiaries, and other beneficiaries pay no or very little tax. So SARS would never uncouple the two, I think, because before you can use the trust income and capital gains to distribute to beneficiaries, you have to apply the attribution rules, which means it's going to be attributed back to the funder, and it's going to be more tax payable. A lot of accountants are not even aware of the attribution rules of Section 7. It's not Section 7C, that is Section 7.2 to 7.6. And we're looking there at a funder or donor situation. So if you or your client have transferred assets into the trust at a soft loan or donated assets, and the soft loan, they use a market-related interest rate. So see what we have to do now as trustees, and communicate that to the accountants and the tax practitioners. What do we regard as a market-related interest rate for these? Because once SARS is auditing us now, we're going to have to demonstrate why are we applying this market rate. So without having to go into too much detail, obviously the attribution rules is a beneficial kind of a provision now, because if you have your ducks in a row and you know exactly which asset funded which, or which asset was funded with which kind of a loan and the amount thereof, you can track it and do the calculations. It's a complicated calculation. It's a cumulative calculation, and it includes income and capital gains generated in the trust. So it is not something that can be done sloppily. So it's going to be really important to keep track of this, apply a market-related interest rate, and then attribute at the right time to the donor or the funder concerned. And when we look at a market-related interest rate, it is a beneficial provision. The attribution rules, potentially, if you run your numbers, you could potentially pay less tax. So we want to apply that. And a market-related interest rate, who would lend money to a trust that's illiquid? It does not really have any other assets in. So you could potentially push up that rate a little bit to your advantage in a wicked way. So the attribution rules in terms of Section 7 can be beneficial. You have to run the calculations, and it's compulsory. You just have to have your paperwork in order to demonstrate to SARS which assets were funded with which loan accounts, and then secondly, what is the market-related interest rate you apply per loan, because they may be different as well. Then donors or funders, where these deeming provisions apply, must declare trust income and capital gains attributed to them. So that's not just the trust. Now we need to communicate that to the donor or funder, and they better make sure in their tax returns, whether it's non-provisional payers, then annually. If it's provisional taxpayers, they are going to have to report that in August, so we need to probably communicate that to them. So yeah, a proper calculation is going to have to be performed, and more importantly, communication to these people ahead of time so that they can submit their provisional tax returns. Clearly, what sneaked into the trust tax return is also beneficial ownership information, which they require. Had a conversation with SARS, and although a beneficial ownership definition was not added into the Income Tax Act, they have a set of rules of information that they require. It is not exactly the same as what we require for the master, or when we are acting as an accountable institution in terms of what we have to keep for our clients. They have their own set of data that they require. So it's important for trustees and accountants and tax practitioners to remember the fields that's required for the tax returns and to provide that information on there. Okay, and that is their definition. It actually includes the beneficial owners, and they got a little bit of a tail there, and those who may gain financially from the proceeds of trusts need to be reported as well. So anything that you gain financially. Now, I'm not sure whether a trustee who charges, high fees, benefits financially. If you're not a trustee, you were advised to keep out of being a trustee, beneficiary, whatever. Whether you're buying a property at a much reduced rate from the trust for estate planning purposes, we know all these structures. That's probably now caught into this last little bit of a tale as well. Okay, so when the poor tax practitioner now submits the tax return for the trust and have to provide beneficial ownership information, they must remember that that information is now also provided to the master and should be on an ongoing basis by the trustees. SARS have got access to the master's portal now. So clearly they are going to do their own reconciliation. So it is so important that the tax practitioner works with up-to-date, real-time, correct information. Otherwise, you will have audits and will have a hard time to explain the discrepancies. There's also a new requirement to upload mandatory supporting documentation with a tax return. I don't know how many people have seen that. I made it in bold, red, underlined, because this is probably the most scary new introduction for me, just considering how far removed the tax practitioner is from the nuts and bolts of running the trust, especially if they are not a trustee. And normally there's pressure on deadlines to actually submit these tax returns. So what have they got in mind there? Mandatory supporting documents must now be uploaded and submitted with the tax return. And there they want the trust instrument. So this looks like an annual thing, because remember they have asked in the previous visits, have the trustees changed? Have you amended the trust deed? It looks like now they want it annually. So if you have amended a trust deed, you better submit it to the master, because SARS has got access there, and the trust practitioner. A tax practitioner must make 100% sure that they have the latest trust instrument and not sitting on an old version. And remember, trust instrument amendment is valid from the date that the relevant parties have signed the relevant trust deed amendment, not when it's lodged with the master. So the effective date is the date of signature, which is on the contract, the trust deed. So that is the effective date, and we need to make sure we report the beneficial owners. For example, the beneficiaries listed by name in the trust deed, has that been amended? So can you see why I'm saying the poor tax practitioner is now becoming the final reconciler checker, that everything stacks? And unfortunately, if I were you, I would definitely charge for that. So over and above the trust instrument, they want annual financial statements. Now that's an interesting one. And I know in the Trust Property Control Act replacement, they are looking to introduce that trustees have to compile annual financial statements. However, currently, it is not a requirement of the Trust Property Control Act to have financial statements. So I wonder what SARS would be happy with if we just give him like a spreadsheet or something, because what we have to keep in terms of the Trust Property Control Act is actually an asset register, not financial statements. So it'd be interesting to see what format they would be happy with. What also have to be uploaded are all the resolutions. Is that not a shocker? So see how clever they are now. And they want minutes of trustee meetings. So years back, I've chatted to SARS, and they said it's going to be the easiest thing. They're going to pick up the trustee and say, right, give us the minutes of the meetings. And if you say, oops, but we don't have minutes of meetings, they say, but your trustees say you'll meet at least once a year, or 3 times or 4 times, or every quarter, whatever the case may be. So if you disregard your trust deed, let's go and dig a little bit deeper, because we probably have got to do with an alter ego trust, which is an extension of oneself. You just disregard the trust deed and treat the assets as if they belong to you. You didn't even know that you have to keep meetings, etc. So, and then SARS can attack that trust. So be very mindful that we remind our clients to, on an ongoing basis, keep resolutions. It's not something you do the financial statements, the tax returns, and then we reverse engineer and see, what resolutions we need to keep. Let's manufacture, trustee minutes, etc., etc. So this is going to be real-time, ongoing, and the tax practitioner has to live pretty close to these so that they know this is the final list. Again, becoming the final checker what does a trust deed require? Is it one meeting, more meetings, whatever? Do I have at least one set of minutes? The resolutions, have resolutions for all the important transactions, because a trust is run by resolution, and a lot of people forget that. And you can't have like a blanket mandate to do whatever you want. That flies in the face of how trusts work in South Africa. So you have to make sure that at least for the bigger important transactions, you need resolutions. A lot of people ask me, what do we need now, a resolution for bank charges every month? I think that's kind of overkilling. Obviously, those you would address, like the repetitive small costs, whatever, which is a given, you treat in your annual minutes, and then the trustees can just ratify all those transactions that happened and that are reflected in the financial statements. And then SARS said these requirements will vary according to the trust type. So that's going to be interesting to see, how they differ in terms of different trust types. For SARS is the only one who speaks about trust types. The master does not know, a special trust, a RAF trust, a medical negligence trust, which I think it's really important for the master to know, especially given the fact that there's, so much shenanigans around the road accident fund trust, the medical negligence trust, and those. So we require these documents to be complete, accurate, and up-to-date in a real-time fashion. Times are up, as I say, to reverse engineer to find out, what resolutions you need. Let's just quickly manufacture minutes, and now somebody has died, so it's going to be really problematic now. Then they also deal with beneficiaries of trusts, where they remind the beneficiaries that they must declare income that was vested in them by the trust during the year of assessment in the respective income tax returns. Now, obviously, the IT3T's purpose is for the trustees as third-party data providers to provide this information to SARS, and then for SARS to use this information to pre-populate beneficiaries' income tax returns. So I think in the event that I'm just going to put everybody on mute here. All right. So in the event that your tax return does not reflect any income that, and obviously capital gains have been vested in you, you need to make sure that it's reflected on your return. It's the individual taxpayer's responsibility in terms of this communication. And clearly this information, the trustees would have to make sure that the correct information is communicated to the beneficiaries to include in their respective tax returns. Now that could be if the beneficiary is a provisional taxpayer already as soon as August and February each year. And then if the beneficiary is a non-provisional taxpayer, obviously when they do their tax returns. And we will see now that the government gazette has come out recently, where the IT3Ts will now have to be submitted actually before these returns are due, and that's now 30 May of each year and no longer September. So they moved it right back. So we'll see later in terms of the timelines what one would have to do. So the government gazette came out 30 June, which deals with returns of information to be submitted by third parties in terms of Section 26 of the Tax Administration Act. And in there, specifically zooming into what is happening to the IT3T, I just picked out all the relevant bits that deals with the IT3Ts. The following persons are now required to submit the return as specified in paragraph 3, which we will have a look at. And they include there a trust as defined in Section 1 of the Income Tax Act, that is a resident as defined in that section, or a non-resident that's required to submit an annual income tax return. So all taxpayers, all trusts that have to register as taxpayers now have to submit these returns. They have, however, excluded, and I've been thinking about it a lot when I did these slides, they have excluded collective investment schemes as defined in Collective Investment Schemes Control Act, a portfolio of collective investment scheme, and any portfolio of a hedge fund collective investment scheme. Now, a collective investment scheme is where two or more members of the public invest money or assets together. And typically here we think about unit trusts, mutual funds, etc., etc. So there, I think clearly they have got nothing to do with typical family trusts, which are used to distribute to minor children, etc., etc. So I can understand that. The employment share incentive scheme trusts, I am struggling a little bit because I think they may have a leak here. So I was thinking, what do these employee share incentive scheme trusts receive? Typically dividends. But what happens the time we actually receive capital or capital gains? So important to take note that we have, however, got those two exclusions of trusts that don't have to submit IT3Ts. You can see all other trusts have to do that. It's only these two that have been excluded. So when we look at information that has to be captured on this IT3T, 2.15 is trusts. And the information that they are after is any amount vested in a beneficiary, and that could be income, net of expenditure. So that is what we're going to communicate: income, net of expenditure, capital gains, and capital amounts. Now, for those of you who've been involved in the early discussions with SARS and the earlier business requirements document, initially SARS contemplated including things here such as loans to and from beneficiaries, etc. And SARS have changed their minds, and they are only requiring amounts that are vested on the IT3T going forward. So no risk information would be requested on the IT3T. That is reserved for the tax return, where they are going to ask all those questions in terms of loans, interest rates, etc., etc. And again, make sure we remember the market-related interest rate, even though we may not charge that on these loans that may attract the attribution rules. So the form that they are after is the IT3T, and it could also be data compiled in accordance with the business requirements specification. And there are different ways to actually submit this kind of information. So no longer loans, etc., that they want. Then the due date for submitting a third-party return, and the shocker news for many probably, is for trust 2.15. Returns mentioned in the above table containing all prescribed information in respect of the period from 1 March to in February each year must be submitted a couple months later, 31 May, every year from next year. The manner of submitting a third-party data return, the option is obviously to do it electronically, but there are alternative arrangements that SARS may allow, but the starting point is electronic submissions. I will have a look at the channels now. So I asked SARS kind of what next. A lot of people asking me, is September still on? What must we do? Is it on ice? Is it something we can prepare for? Because you can see these time frames that we're going to speak about soon. You would see that you can't wait till the IT3T is due to then jump out of the woodwork and get out of the blocks to submit the numbers. There's a lot of work that you have to do prior you arriving, and you may have submitted numbers elsewhere already, and then you can't backtrack on that. As we said, the individuals may have reported that on their provisional tax returns. You may have provided for in the trust tax return. So it's going to be really interesting to see how all of these things are going to have to be reconciled. So SARS said there's currently a double process. So they have scrapped this year's September compulsory submission. So they are still working with us early adopters as part of a test group to really just test the system, test the fields, etc. And that will happen during August and September this year. And only from 2024, it will be compulsory to submit by May of each year. So after this, the September testing, then SARS would clarify and finalize the forms and processes, etc. So I think we can expect communication after the September testing as a final, this is what the form looks like, this is the process that you have to follow. Because currently, when you would just look at the submission options that SARS made available initially, they only made available 3 options. E-filing is obviously the obvious preferred one, but you can only do 20 reports at a time. And that is really limiting, especially if you're going to have to do 20 at a time. It's going to take you a long time if you've got a number of trusts. HTTPS is another option. It's literally standing for Hypertext Transfer Protocol Secure. And that is IBM technologies, where you can upload files up to a max of 10 megabytes. I mean, technical stuff. But you will need an ISV. But the problem is here, if we use HTTPS to submit the IT3Ts, and we use an ISV such as a Greysoft, in that instance, Greysoft would be coming up on SARS end as the representative, as a tax practitioner, which the representative taxpayer, which is going to be problematic then. So that is clearly not going to be an option then. Connect Direct is what the banks have been used traditionally, and initially SARS thought that would be the submission channel, similar to the other IT3s. But I mean, they have made 950,000 plus boards of trustees, third-party data providers to SARS. So this is clearly not going to be a very feasible option, because it costs millions of rands. It's older technology, and e-filing is definitely the preferred option. And SARS is currently working to improve the submission ability through e-filing. So we hope after the September testing, we'll have clarification around that as well. So yeah, so what next? I was just thinking, what do we do in the next couple of months, and what do we have to do kind of in the interim? We have to get systems in place to have real-time, up-to-date data, as it actually is intended for trusts, because we said earlier, trust is run by resolution. We should have that on file. Minutes of meetings we should keep, like we have to do. There's nothing new that SARS really introduced here. They just requiring information, you know, what we are already having. So I'm saying for August this year, we need to have our ducks in a row. We need to be very careful about the attribution rules here, because a trust is a taxpayer of last resort. First we attribute, then we distribute, and then it's a trust tax return. So we need to do those calculations, communicate to the relevant taxpayers, and then the trust is the remaining one to submit data. So coming August, careful about the attribution rules, because the donor or funder are probably going to have to include that in the provisional tax returns. Then you can distribute and let the beneficiary put that in their provisional returns if relevant. And then what's retained in the trust, you submit as a provisional return for August. When we fast forward to February 2024, again, careful about the attribution rules. After we apply that, we distribute and let the beneficiary put that in their provisional returns. And then what is retained in the trust, we put in the trust provisional return for in February. Then we fast forward to May 2024. We're going to submit ID3Ts for all distributions made since 1 March to 28 February 2024. And that would clearly include all these things at the top here that we have distributed to the different beneficiaries. If it's a nil return, you also have to submit nil returns. So that's just kind of an extra administrative burden on boards of trustees or tax practitioners. So that is the way it stands currently. And when we then fast forward after we submitted the IT3Ts, clearly SARS is going to use that to now pre-populate the individual beneficiaries' tax returns. And there we need to be very mindful to have our ducks in a row there, because the attribution rules have to be applied, which is rule number 1. And rule number 2, distribution of the tax return must tie up to the IT3Ts, which we've communicated to the beneficiaries. And then the trust tax return is the remaining one after we applied number 1 and number 2, and that's the washing machine. And there, I just want to warn, and SARS have warned about that as well. We need to be careful about the apportionment of costs, because accountants and tax practitioners have been very creative with coming up with the best possible tax position for their trust clients. So be very mindful about the apportionment of costs, that we can demonstrate to SARS that they have been treated correctly and fairly. And then the beneficiaries, obviously, their returns must show the distributions, and again, need to tie up to the IT3Ts. And remember, in the event that it doesn't, it's the beneficiary's responsibility then to notify SARS that the amounts distributed to them are not accurate. Right, so I don't know if anybody has got any questions. That pretty much covers our session today. I'll have a look in the chat box quickly. Okay, any questions, any comments?
I think just, may I speak? Can you hear me?
Yes, I can hear you.
Half here. Just in connection with the submission of that IT3T for 2024, if it's the distributions for the preceding year, the 2024, February ended 24, and banks have got the same reporting deadline as we'll have with regards to capital gains, in a number of instances, we've got to wait for the capital gain tax certificate, especially when it comes to the unit trusts, in order to do the financials for the trust and then make the distributions. Having said that, you might have done an allocation of distributions at the end of February anyhow for the vesting, but to do and confirm the figures, it's going to be extremely tight in that banks have got the same deadline as what we'll have to report the same figures as such.
That is absolutely 100% correct, Cheryl. When I spoke to SARS, I thought they're going to, when they started making noises, they're going to move it forward. I thought end of June. So I asked them, how long does it take SARS to kind of pre-populate individuals' tax returns from third-party data providers? That's days. So I thought, right then, June makes a good sense, because then at least we have a month, which is also kind of not enough. But they have moved it right back to May. I think there's going to be a lot of pushback, I think, over time, and there's obviously huge reliance on the financial institution concerned to get that data out as soon as possible. Right in the beginning, there was talk about, SARS going to allow like a discrepancy, like if we're 90% correct, like we have, with the provisional returns, is that going to fly? Especially now that they have brought the state forward or in line with the other IT3T providers. So it's going to be interesting how it pans out. I think it's going to be a lot of pushback. So yeah, one would have to wait and see. And just interestingly about the Section 25B, it looks like SARS, through their systems, through what they're asking, through when they want information, it looks like they are going to apply Section 25B to the T, which means you actually no longer can just rely almost on a formula or a resolution, say we're distributing all the income or all the capital or percentage to this person, that person. They're actually moving towards real-time data to say, I award rand and cents to this beneficiary and that beneficiary, which is actually what 25B is saying. I think they've been lenient over the years just because people just don't have the information. So just to have a resolution with the formula, but can you see now when we have to submit the resolution, what is that resolution going to say? Is that tying up to how it panned out on the distributions and the IT3Ts?
Yeah, we've definitely got a disclosure problem and or a reconciliation between two sets of information at that time.
Yeah.
Yeah. Okay. Thank you as always.
Yeah. Any more comments, any more insights that I've missed? And there's a question here on passive trusts that have not to date been registered with SARS. When are these required to be registered, and will one have to comply a complete return since inception of the trust? This is the scary one. Remember, SARS now have access to the Masters portal. All those dormant, let's just use dormant trust here, or passive trusts that people just never registered, that the 300,000 odd, according to the statistics. There is a cleaning up of book, and I think it will be really important to go through the records and identify them and communicate to the clients where they haven't been registered, because remember, every trust, so that you look at the Trust Property Control Act, and that includes every trust that's registered with a master. If it's an oral trust, the master, SARS would obviously not know this, but once it's registered with a master, SARS is going to know. You have to register for tax, and then you have to do all the historical tax return. So that can be a monster of a cost. And if I were you, I would not let SARS knock on your door to say, look at all these trusts that were never registered for income tax, let's hit you with penalties. So it is really important while we're cleaning our book to make sure that we highlight those problematic trusts that people never paid for. You probably lost contact with them, etc., etc. With the IT3Ts, does this mean all trusts has to be registered for pay-as-you-earn? No, pay-as-you-earn is an employment thing. IT3Ts, that is distributions by trustees to beneficiaries. So it's specifically for distributions. It's got no other relevance to employment or anything else. Okay, copies of slides for those who haven't gotten it. I get a bounce back on from some people on the emails. So if you don't get the slides and the invite to next month's meeting, just let me know, and I'll see what I can do, because my emails is something funny there. Okay. Okay. Any final comments? Okay. What's the latest on the compliance register of beneficial owners and insecurity at the Masters portal? Oops. The master was the first entity that was fined earlier this year. I've sent out communication a while back where they have the information regulator under POPI have given the master 30 days to comply, and clearly they haven't complied. So I think this is a big thing, and especially given the fact that they haven't renewed the security certificates. I'm not even talking about the format that we have to submit the beneficial ownership report on the Masters portal. We're just talking about security in general. So yeah, the powers to be is probably going to have to intervene and make sure that the information is protected. And again, a lot of people are not submitting information because they say they can't expose their clients. I don't think you can advise your clients against the law not to submit, because they will hold it against you and they get the 10 million fine. I think you need to explain the risk to them, and it's up to the trustees to make that decision. But I'm not sure whether you're going to be off the hook if when the master actually do their rounds. Yeah, so just to clarify, 2023 September is going to voluntary, not compulsory. Okay, how can we check if a trust has been cancelled? A few years ago, I had 3 trusts, and my accountant said that she would cancel them. Can I check that if there's a cancel? There's 2 places. When a trust, so maybe quickly about that. So when a trust terminates or you want to deregister it, the trustees can terminate it. It actually has to be physically deregistered with the master, because only then will SARS stop their nagging to submit tax returns and to be registered as a taxpayer. So you terminate the trust as trustees, you deregister it with the master, and you have to deregister it with SARS. So there's 2 places you actually have to submit documentation. It's quite a fat list. The Chief Master Directive in March 2017 gave us a good list there. And interestingly, the Master Directive did not deal with tax clearance certificates, and recently we've seen some of the Master's offices now asking for tax clearance certificates. So you have to make sure you do the historical tax returns if you haven't been registered as a taxpayer, or if you're just behind. Okay, thank you very much, everybody. Have a good weekend, and I'll send out an invite for in about a month's time, and then we'll probably talk about what do we do. SARS knocks on your door, what information we have to keep, etc., etc. Goodbye.